No, you're like there.
Okay. Thank you very much for joining us at the webinar about Virginia's Guardian Ad Litem program. We are pleased to have Jean Kelly, Vice President of NewFound Families, and David Guardian Ad Litem joining us today for this presentation. Thank you for being with us, Jean.
Thank you so much for inviting me to talk about serving children as their guardian ad litem. It is an honor to serve the courts and children in that capacity, and I'm glad to be talking about this tonight. The PowerPoint that's been put together is information from the Virginia Supreme Court website and from the Office of the Executive Secretary. And that is the administrative branch of the judicial part of our government, the Supreme Court of Virginia. And the Office of the Executive Secretary handles the certification of guardians ad litem. They have developed a definition of the role of guardians ad litem, and that's provided in your first slide. But when people ask me about that, I try first to say, I am a lawyer. You have to first understand that I am a lawyer. So I am subject to all of the rules and rules of conduct, professional responsibility rules that any other lawyer is required to abide by. I am not a therapist or an investigator or a social worker, but I feel like all of those things play a part in developing a recommendation to the court. But my approach is one of presenting a case on behalf of my client, and my client are the children that you are caring for. Guardians ad litem are appointed not only in foster care cases, of which you're involved, but also in custody cases, and I'm often appointed in delinquency cases when children are charged with a crime, and I'm appointed often in a child in need of services case. When I'm appointed as a guardian ad litem in a child in need of services case, my case starts often as a CPS case. And I tell you that because many cases start as CPS and then become foster care cases. So I know a whole lot about the family before we ever get in the foster care system. And I think that is something that you may not know because you would be new as we start the case as a foster care case. So the guardian ad litem in all of those types of cases is required, is asked to do certain things to develop an opinion, a recommendation for the court. And the first thing that's always listed is meet face-to-face and interview the child. And that's a recommendation. Guardians ad litem, there's not one set pattern, and you probably have experienced that. There are different styles to the way attorneys approach their role as guardians ad litem. I can tell you that I love meeting with babies, but if I have other cases and I can't get around to holding a sweet baby, I'm going to depend on you telling me about that. But if a child is 10, 11, 12 and older, I definitely meet face-to-face with that child. And I'll often do that in a setting which I hope is comfortable for the child. Because remember, my role is child-focused. I'm concerned that that child is not, that I don't add to the anxiety that that child is experiencing. And I don't like to, I'm always looked at as the court. Something bad has happened by a child, often by a child. So I try generally to meet with them, even foster care cases, in a school setting, so that I look like the librarian and the principal and the teacher and guidance counselor. And it makes sense to them when they come to the guidance counselor to be asked, to be interviewed, to chat with them. So the second item is an independent investigation, and that's, I have a court order. The judge has entered an order which requires therapists and doctors to speak with me, and schools to be open to me and provide information without requiring me to file documents in court. And that's very important for me to gain information about the child and the family. I participate in mediations and negotiations as I'm given notice, and in your case, it's family partnership meetings, and I try very hard to participate in family partnership meetings. I'm interested in how families react in those meetings, and if you experience that, it can be telling in those family partnership meetings. Advising a child is a difficult responsibility. And so you have to consider the child and what they've experienced and what they can handle. So it doesn't mean that I sit down like Law and Order and talk with a child in my office, because that's intimidating, even to adults. Now, some of these don't apply. Some of these recommendations for what a guardian ad litem should do, they don't apply to foster care cases, but most of them do. Children should not be in the courtroom, so preparing a child to testify, I've been practicing 30 years, and I have fought like you know what to keep a child off the stand. The courtroom is an adult arena, not a child's arena. The child should not be subject to that. If you've ever had to be a witness, you know how scary that is. And I, as attorney, I love being on the other side of that, but I've had to be a witness, and it's hard to even remember your name. So I don't want a child to be subject to that. But I do communicate with them, and I do meet and try to, particularly teenagers, hear their perspective. I am required by the court to tell the court what a child wants to happen if they are 12 and over. But I'm also required to tell the court what I believe is in the best interest of the child. And it requires for me to do all of these things in order to gain that information. To be a guardian ad litem, I have to take classes. I have to be approved by the judge. I have to prove myself before I was certified. I had to prove myself by having a mentor, following somebody, handling cases with another attorney. They don't just let somebody in a courtroom and rock and roll as guardian ad litem. You do receive training, and you are required to continue that training. So as you have probably received this information, I received recently a lot of research on brain injury, and also parents who've experienced abuse as when they were children, and the impact that has on how they raise their own. So there's lots of interesting research going on right now, and we're required to keep up with that and to show that by filing documents with the Supreme Court, the Office of the Executive Secretary. And you can see here we have a whopping fee for doing that, and so you know that we aren't guided by that. So in working with a guardian ad litem as a foster parent, it's an interesting role. I have asked foster parents to be witnesses in cases, particularly in the termination of parental rights, because you know often you are the one person who knows the child from the beginning, or knows the child even at that moment what they're going through. We don't see the child at night when you're putting the child to bed and their concerns are expressed to you, or the acting out that they do, that you have to hold them in a car seat so that they can work through that frustration and anger. So expressing that, I always want to hear the positive things about my client, my child, and the negative things, because the court wants to know that. One of the best things recently that foster parents did for me in a courtroom, I did a foster care review, and I said, bring me pictures of your children, because the court needs to know who they're talking about, who they're making a decision about. And when you see a little face, that helps you say, I know now who I'm making this big decision for. Because as you know, in these cases, it's not the parents, it's what's best for the child. Every guardian ad litem wants to be given information, because I look great in the courtroom with more information. Let's just get down to it, right? If I stand up and don't have a thing to say, why am I there? So I need that information. I'm interested in your journal. I'm interested in how the child has improved in your care. Or I'm interested in, do you think my child needs a therapist or needs different services? I want you to tell me that. And so the question is, how do you tell me that? It is often easier to tell me by email. I want to talk to you, but I'm in the court. I'm in a courtroom 3 days a week. So it's hard to get back to you in a timely manner. But if you and I talk one time, even as the courthouse, and then you're emailing me, if I see something, I'm calling you back. I'm keeping the information. We both have the same goal, and that is finding the best place for our child to be and grow up and be healthy. I can go through these tips, but I think they're self-explanatory. So let me see if we can have any questions. And this parent's guide, these are links where you can, the first one is there's a whole list of Guardians Ad Litem, and the great thing about that one is it has my telephone number and my email. So if you say, I never get to talk to that Guardian Ad Litem, I don't know how to get in touch with them, go on to that website. I think it's in alphabetical order and by judicial district.
And they give you a map.
And they give you a map where the judicial districts are. So I'm certified, but I'm certified to be in the 15th Judicial District. And I choose to take cases from Spotsylvania and Stafford. I can choose to take cases in other localities, but I've limited myself to that. So the judge decides who, on a list of attorneys who are qualified, who've completed all the requirements, whether they should give cases to that person. So I don't serve all over the Commonwealth. No one serves the entire Commonwealth. You're in judicial districts. So if you need to look up someone, that's the place to go. I think the timeline guide is really important for you as foster parents. The timeline is our guide. It's our argument for the child. Parents have a limited amount of time to cure what has caused the child to come into care. Now, I know that it's the policy of DSS to reunify the family, and I know you want that. But if it is in the best interest of the child to move on, there's a set time limit for the parents, not the child, the parents, to accomplish the requirements. And when we end that timeline, I'm as Guardian Ad Litem, I'm not so much on giving them extra time, because my child needs permanency. My child needs to move on. Let's see. So questions.
We've had some people come in with questions too.
Great.
So, if you'll read the question so that it'll be in the record.
Should I expect the Guardian Ad Litem to visit the child in my home, and that's the foster home? You should not expect that. And you may have been guided that a Guardian Ad Litem is required to come to your home, and that's not one of the requirements. So in custody cases, I generally go to the homes because I want to know whether the home is clean and safe and the child has a bedroom. I know all of that is true in your home. If I can talk to you and get the information, that's what helps me as guardian ad litem. If I can talk to the child in a safe, easy environment like the school or the daycare, I'm going to choose that because I accomplish a couple of things. I get to see where they are, how they interact with the kids at daycare or the kids at school, and I get to see the guidance counselor and the teacher. I get to watch them in a classroom. That is not to say that the guardian ad litem will not come to your home, because again, guardians ad litem, everyone's different, and they can choose how they handle their case. And their representation, remember what we talked about in the beginning, we're lawyers. So we're developing our case. We're trying to create our recommendation, which really is our theory of the case, what we're going to argue. So I might come to your home, but I should not be expected to come there. I know it's a great home. But if you think there is something that the child would feel safer talking to me in your home, I'm willing to hear that and understand that. So don't just shut that down. How involved is the guardian ad litem in formulating the child's full disclosure statement prior to adoption? None that I know of. But that doesn't mean that there may be other guardians ad litem that participate, but in my 30 years, I've never participated, have never been asked that. And when an adoption gets to circuit court, a GAL is usually not involved. And I say that, and I'm already involved in one. So,
who would do that? Who would they be expecting to do that?
Probably the DSS is required to do that. I also represent a social services agency, have done that for 28 years. And I would expect them to do that, and I want to see the piece of paper as the person doing the adoption. So probably the social services worker. And they might call me in as the attorney for the social services to help them with that. How much influence does the guardian ad litem have in the court's decision? In my jurisdiction, a lot. When a judge, in my jurisdiction, judges have become comfortable with the guardians ad litem that they have on their list. And I have often gotten a case where the judge says, oh, give it to Jeannie because whatever, down the line, it's something that has happened. Because they know that an investigation will be completed. And there are many guardians ad litem like that in our judicial district, and I think in the Commonwealth. So the guardian ad litem is the last person to speak before the judge renders an opinion. That is really a great position to be in. Nobody comes against my statement. Generally, nobody objects to my argument. The other attorneys try to anticipate my argument, but I get to talk right before the judge renders his opinion. So it's an important position, and it depends on the judge, and it depends on their reliance on GALs. Okay. How often should we be interacting with the guardian ad litem? I think that depends on probably not. Let me just answer this. Not a lot. Not a lot. The guardian ad litem is really not supposed to discuss the case with you. Remember, the guardian ad litem is an attorney. There are confidences to be kept. They're required to keep some confidences. You are not a party to the case. You are so important to the case. Oh, thank goodness you're there. But you are a witness. You are, and I would not discuss the case with other witnesses. However, I have some difficult cases, and I really want to hear what's happening in the house. I want to hear how the children are going to bed, cooperating, maybe having meltdowns. Is the therapist working? Do they need more? Is it just they're not there's some problem with the other children, because maybe there's something I can file in court to help my child in those situations. And I can't come up with a specific, well, I can say a different service. I can certainly file for a different service or additional services. But how often? Probably not a lot, and probably the guardian ad litem is depending on you to provide, would like as much information as you would give. As a foster parent, when is it appropriate to go to the guardian ad litem if you feel child services is not being responsive? Always. It's always appropriate. Do it. Do it. As a foster parent and a guardian ad litem, we are both concerned about the best interest of the children. And, you know, some agencies may have many children that they are handling at the same time. But you and I have this child that we are concerned about. And it's important, particularly in foster care cases, that we continue to watch over the services and make sure the right services are being offered. Sometimes social services, you know, they rely on the therapist, and you already know something additional that the therapist is told. Go to the guardian ad litem. Guardians ad litem and DSS work together. They can get copies of every single piece of paper that's in that file, all information. So the answer is anytime you want.
And what is the best mode of communication with the GAL in that case?
In that case, it's a telephone call and right away saying, I really need to talk to you, I'm having a problem. Because then I'm going to get to you, but it might not be till 8 or 8:30 at night, but you're going to answer me because it's 8 or 8:30 at night. And I might leave a message saying, hey, can you call me after work or during lunch, whatever. But it's a call when you're having a problem. And then because I want to ask you questions about it. If you send me an email, it may not be enough information. Or it may be an email saying, call me after dinner, and I'm fine with that. All guardians ad litem are fine with that. If the timelines are not being followed, what can we do? As foster parents, I'm not sure that there's really, as much as I hate to say there's no role.
They can file for an appeal at social services, the state level.
Okay, you want to talk about that? There's an appeal at the state level.
Yeah, there is a process that was introduced a couple of years ago, maybe longer, that created an appeal process in foster care. So if you are a foster parent and the child is not getting the services that they need, which would include timely implementation of the foster care plan and all of the timeliness issues of the court, you can actually file that with the Virginia Department of Social Services in their appeals division to appeal the lack of services or untimely services to the child.
So how scary is that? You know, that's really scary. So calling the guardian ad litem, because the guardian ad litem wants the timelines followed and would have more knowledge and flexibility to file something to get the case heard sooner. So that would be the best approach from my perspective and an understanding, because the guardian, you may not truly know why it's been continued on. So you might get additional information on why the timelines haven't been followed, but the timelines are supposed to be followed. You have another one? What determines if a child gets a GAL? In foster care, they always get a GAL. In foster care cases, in a CPS case, on a child in need of services, which usually comes out of a CPS. In fact, as a guardian ad litem, I have filed a child in need of services. And you would have a guardian ad litem appointed by the court automatically. There are custody cases where a guardian ad litem can be appointed, and delinquency cases. And those depend on the judge. It's what the judge wants. But in foster care cases, there are always guardians ad litem. Can the timeline be accelerated if the parent is not doing any of their assigned task? Yes, it can. Yes, I have one right now I want to accelerate. And often one can't be found and one's in jail. That can be done pretty quickly. You do not have to wait. And so who makes that decision? It would be made by social services and their attorney. So when I represent social services, I'm working with my client, social services, to decide what I will file, because that's my case, okay? So when you go in on a foster care case, that case belongs to, the petitioner is the attorney representing the Department of Social Services. So they're the lead. So yes, they can be heard sooner. What's the difference between a guardian ad litem and CASA? A guardian ad litem is an attorney. A CASA is a wonderful volunteer who has been qualified through classes, has the right to go into the home and talk to all kinds of people, and they provide a report to the court, and it's often just sent to the court and not to anyone else. They have expanded powers in the code to do that. But a guardian ad litem is an advocate, is an attorney who stands up in court and argues for the child. Do we have any other questions?
We do not have any other questions.
I hope I haven't talked too fast. I'm sorry.
We have not. Let me go through this 1 second. I'll turn your volume off for a second. Just a minute.
All right, does anyone have any other questions? Okay. Well, we thank you all for participating tonight. Please raise your hand if there's any of the questions that have been brewing in your minds, and let us know that we've answered some of your questions. Thanks, Lisa. Thanks, Laura. Lori, I see you on here. I am going to, if it's okay with Jean, she had an issue come up in court regarding bonding with the child. And she might like to ask you a question. Because in the court, she had an issue where they're giving more time for the family, and the child was bonded with this family for 15 months. Would you like to take that one?
She can probably answer the question, ask the question better than me.
I'm always worried about it. I'm always looking for the argument to be made before the court, because that's my job, on the bonding of a child, because how hard people fall in love with children quickly, and when the child has bonded and they've been there for 15 months, then I want to move to have parental rights terminated and to move on. And I'm not remembering exactly the case, but we've had, and it happens a lot, because children often don't reveal in our short time that we meet with them, but they may reveal to you how they feel about going home.
Okay. Someone else wants to know, does the GAL submit their report straight to the court or to Children's Services?
Oh, the Guardian Ad Litem does not have to submit a written report. And I've taken a course where there was a panel of judges, and the report they wanted was, who did I talk to? Just so I'm covering the basic standards. If I do a report, again, I sit as an attorney, I would have to give it to the attorneys. If I do any kind of thing, any kind of written document I submit to the court, I would also submit to the attorneys. Now, my bill is submitted to the clerk's office, and it's paid by the Office of the Executive Secretary of the Supreme Court, not by social services. But I don't provide anything directly to social services as far as a writing.
Okay, thank you. How long do you feel it is reasonable for a child to stay in foster care?
You know, all of these.
Yeah, repeat it. Repeat what I just asked you because they can't hear me on the mic. How long do you feel?
How long do you feel it is unreasonable for a child to stay in foster care? So all cases are case by case, right? You know, we don't have a set of facts that apply all the time. But I think that the timelines were created based on research and not just based on politics. So I'd like to rely on the timelines. But I think we also have to think about case by case. If a child is with you for 2 years, how do they even know the parents, right? They don't have they just have biological parents because you've become the parents. So there is some common sense to how long a child can actually be away and just have a little visitation, and there's no bond created. Who determines if parents are paying child support? Is that something the GAL determines or social services? Child support is a division of social services, but we don't really interact. The Office of the Attorney General in Virginia has specialized attorneys that are child support attorneys, and their cases are all set on different days. So in my foster care cases, when I represent social services, I always draft the orders ahead of time to help the judge. And in that, I can check a box because it's a form order that says, and ask for child support. And then when that is processed, the system, it goes over to child support. If that money ever gets back to DSS, I don't know. It was about 15 years ago, it was a real issue. But the Division of Child Support Enforcement, who handles that, is a part of social services, and it is an automatic request in the first court order which approves the foster care plan. If you get a foster child and you don't hear from a GAL, can you request one? No. The GAL is appointed by, as a foster parent. As a foster parent, you cannot. And the GAL is appointed by the judge and has to be appointed. So there is one. You just don't know who that is. So you're probably going to ask social services, who is it? And do you have a telephone number? Or who is it? And I'm going to look them up.
And
they can call the clerk, but I don't know that the clerk, you know, the clerks are really funny about giving out any information, particularly on foster care cases. But at that first hearing, you will see a guardian ad litem appointed. And that's not the removal hearing, or it might be the preliminary removal hearing that you appear at, but it's definitely at the adjudicatory or the dispositional hearing. You're going to see a guardian ad litem, and that'll be the last person who talks. And approach that person. I don't mind being approached at all. What if we as foster parents have concerns about the GAL doing their job? The GAL is really if you look at let me go back. If you look at the Supreme Court website, if people have complaints about a GAL, they take it to the judge in that jurisdiction. So if you have a complaint about me as GAL, you would make a writing to the judge who's handling the case. But understand that judge has chosen that guardian ad litem. Okay? And the guardian ad litem is not required to inform the foster parent. The guardian ad litem is the attorney representing the child's best interest, not representing the child, but making a recommendation on what that what is in that child's best interest. Now, how can they possibly create that without interviewing people? And I get that. But unless there was something dramatic, if there's something dramatic with the GAL, because they don't have to report to you, they don't have to make an appointment with you, they have to see the child, and they can choose to see the child at school or daycare, then the judge is the place that you would talk to. And not talk to, I'm sorry, write to. There's another question. If a child is under 12 but old enough to have an opinion on court's decision, is it better for the social worker or the GAL to be the advocate? Both should be the advocate. The GAL is required under the law to tell the court. Did it say under 12 or over 12?
Under 12.
Under 12. It doesn't really, 12 doesn't really matter to me. If they're 10 or 11, that's close enough to 12 for me. But it also depends on, you know, how much the child comprehends. But what so it would be the GAL who would be arguing for what is in the child's best interest. Children should not bear the burden of believing that they should have an opinion on where they should live. The research shows that that's like putting bricks on a child's shoulders, because they don't get to make that adult decision. I want to live here, I want to live there, because adults are taking care of them and will care about their best interest. And that's what I often say to children. My job is to do the court. The judge's job is to make a decision. And we go through, teachers are responsible for teaching in the class. And so what is your job? Your job is to be successful at school, to do great at school. And that's their job. So an opinion, that I always listen to it, but then tell them they don't have to have an opinion. But social services should be advocating for their best interest, as well as the Guardian Ad Litem. What happens when a parent who has multiple children, 6 or 7, in foster care and becomes pregnant? Oh, yes. Can social services start the process to take away the unborn or newborn baby right away? And it's newborn, yes. I've got one going right now. I've had a couple we've done. Yes. And I get the doctor's report. I enter that into evidence on the ERO. So yes, it can be done. Because they usually come with other issues. So she's showing me another question here. Let's see.
And they should refer back to one of the slides, because there are standards.
Okay, if the Guardian Ad Litem is not required to visit the home and does not have standards for contact, what exactly is their responsibility besides showing up to court? So let's go back and see. You know that their responsibility, we have a slide that shows their responsibility. Let me address the question as she's written it. I'm sorry. So the slide shows you what are the standard best practices. These are best practices, okay? And they're not, they are the standards for contact. But and Guardian Ad Litem should have contact. Again, I'm not required to have contact with a newborn baby, although I actually have been at the hospital when the baby was born, I knew they were going to do an ERO. So there are standards, responsibility besides showing up for court. So the responsibility is to investigate sufficiently that they can make a recommendation to the court. And you know, it is pretty obvious to a judge when a Guardian Ad Litem has not visited a child and not investigated the child's situation. In your type cases, though, the therapist is often my best friend. That's my witness. And The parents are my witnesses because they're often disasters on the stand in making admissions. So again, I'm an attorney trying to develop the theory of my case. But judges know who is not being, and there's been a big change in the list of Guardians Ad Litem and who's actually used, and maybe that cleanup is still happening. What happened?
Oh, you already did that one.
Yeah.
Okay.
She's looking to see if there are other questions. I'm happy to take as many questions as you have.
Jill Bell, your hand is up. Do you have a question you want to ask? I'm going to lower your hand and put it back up if you have a question you're trying to ask. Jill Bell, your hand was up. So I wasn't sure. Oh, okay, I see. No, sorry. Okay, great. Does anybody else have any more questions? Well, we certainly want to thank Jean Kelly for taking time out of her very, very busy schedule to answer our questions regarding the Guardian Ad Litem process here in Virginia. We will be, some of your questions were whether or not we would be able to give you a training certificate. You will get an email directly after this webinar is over, letting you know that you have attended this webinar. If your agency requires anything further than that, you can send us an email and request something more. My email address is chawks@newfoundva.org. You can find me on our website under the Contact Us tab. And you can send me an email if you need something more than the confirmation email that you attended the webinar. Also, someone asked if this PowerPoint was going to be available. The entire webinar has been recorded, and after we end the webinar, I then send it on to our web administrator, who places the webinar on our website. So you'll be able to see everything and hear everything from this presentation right there on our website. I hope that answers all your questions. Thank you, Scott White, for your comment that this is very informative. We appreciate that.
Thank you.
So thank you very much, everyone, and have a nice evening. And thanks for all the work you do with children in Virginia.